It's 4 o'clock.
All right, so good afternoon to you all, and you're welcome to this afternoon's panel discussion on employment contracting. My name is Jeff Bassey. I'm going to be the host and the moderator for this afternoon's session. So guys, I want to move straight to introducing our distinguished guests, resource persons or panelists who will be taking us through this afternoon's discussion on employment contracting. And first on my list, I want to introduce is Wing Commander retired Samuel J.A. Alote. Yes, he's no more a military officer. Samuel Alote, by way of background, is a trained engineer, a management consultant, and a human resource practitioner, as well as a legal practitioner. He's been called to the bar for some years now. He's currently is the immediate past director of HR and services at the Ghana Great Company, Greatco. Samuel Alote taught in our in-person class today, and our students who want to be sure that if he's still with Greatco, why are we having power issues? But he's the immediate past HR for Greatco. Samuel Alote later moved to head human resources at the revered Stanbic Bank of Ghana for several years. And then later online, he was the HR director for African Online Holdings Limited, Kenya, and the general manager of Africa Online Uganda. Currently, Mr. Alote is the chairman, Environment and Sanitation Group of Jospon Group of Companies. He's also a member of the management committee of the School for Continuous and Distance Education of the University of Ghana, and an adjunct lecturer at the Ghana Institute of Management and Public Administration. He has a wealth of corporate experience, international exposure, his background in HR, and probably more importantly, because of our topic today, I would say that he's also a legal practitioner. Mr. Alote is well placed to serve as a resource person in giving our knowledge in this afternoon's discussion. Jifa van der Poy is one of our resource persons, the young lady in the middle. Jifa is a senior associate with the corporate commercial practice group of Benti Entiel Lecha and Ankoma, the revered or the renowned law firm. Over the past 8 years, she had advised many local and international companies on a wide range of employee-related matters, including contracting, pensions, workman's compensation, immigration, data privacy, and income tax. She also represents clients in employment claims, in negotiations, mediation processes at the National Labor Commission, the quasi judicial body in charge of labor adjudication in this country. You're welcome, Jifa. And then we have our own Senyo M. Ajabin. Senyo is an old guy who have been making these presentations on our platform for several years now. Senyo is a labor consultant and a mediator, as well as an arbitrator listed with the National Labor Commission. He's a trained non-executive director and a member of the Institute of Directors Ghana. Senyo's specialization is in employment relations, mergers, acquisitions, workplace investigations, and employment law. He's had a total of 17-year work experience, 3 in dispute resolution with the Judicial Service, Deputy Director of Projects, National ADR Coordinator. He has had some 14 years practice in the role of HR. He has headed HR for some banks and currently with a construction company. Stenyo actually studied minerals processing at KNUST and later His masters were in the paralegal areas, ADR, and now a labor expert. Senyo will want us to know that he's a sex therapist, and if you are interested in his services, you can always call on him. He's currently the country manager, like I mentioned, of WBHO, a multinational civil and mining construction firm, and also a certified senior professional in human resources. So folks, here we are with our resource persons for this afternoon, well-versed and well-placed to speak to the topics. Let me say a welcome to you, Mr. Samuel Alote, Wing Commander retired. Welcome, sir. Do we have Samuel Alote here? You're welcome, sir.
Yes, thank you. Thank you. I hope you can hear me.
Yes, we can hear you, sir. Jafar Vanderpoy, you're welcome.
Thank you.
Thank you. Senyo M. Ajabin, you're welcome.
Thank you.
Good. All right, so we are zooming straight into the discussion. We're supposed to be having this discussion for about an hour. Thereafter, we would take in a couple of comments from our viewers all over our viewers and listeners, I might say, all over the world. Then we will call it a day. So I want to take off with Jafar Vanderpoy. We are told that ladies first. Jafar, you are an employment lawyer. What would you say is a contract? I mean, in law, what is contract? Then you zero in on what you consider as employment contracts. Jafar.
Thank you, Jeff. A contract is an agreement between parties which creates mutual obligations between them, which are enforceable by law. So in Ghana, contract is governed by the Contracts Act and common law. Common law is the laws that we've inherited from our former colonial masters. The employment contract in Ghana is governed by the Labor Act. And the Labor Act defines an employment contract as a contract that is of service and which could be express or implied. When the contract is implied, it means that it is deemed to be a contract by the conduct of the parties. When it's expressed, it means the parties have clearly stated that this is an employment contract and they are performing contracts under such, under specific terms they have indicated. So for a legal meaning of a contract of service, it means that the parties, that's the employer and the employee, have agreed to one, I provide services, that's the employee, and the employer then pays a wage in consideration of the performance of those specific services that the employee is providing. And then the employee agrees that they will be subject to the control of the employer in that relationship they have agreed to undertake. Then the third thing is that there are other provisions that must be consistent with an employment contract, which are payments of pensions, statutory benefits, payments of other mandatory benefits that have been provided by law. Sometimes there may be also contractual benefits. In addition, that the employer has control over the employee in terms of terminating the employment, disciplining the employee in the event of any misconduct. So generally, that's what the Labor Act says, an employment contract.
Wow, that's rather a long and a complex definition. If you ask a layman what a contract is, I'm sure he would only mention that contract is an agreement between two or more persons for the fulfillment of obligation. But there are a lot of legal issues surrounding it. Thank you so much, Jafar, for the introductory statement on what a contract is or contracting is. Now, let me turn to Mr. Jabin. What would you say are the different types of employment contracts? Would you want to kindly, in an introduction, walk us through what the different types of employment contract, as far as our everyday employment engagement is concerned?
Okay, thank you, Jeff. So let me just start with the most common type of contract that we have, which is the continuous permanent contracts. Often we call them generally appointments. They are permanent and continuous because they go as far as up to 60 years of employment. So it is deemed as continuous until retirement. Then we have a second type of employment contract, which is the casual contract per Section 74 of the Labor Act, which says that a casual contract is a contract that is not more than 6 months, and it is seasonal and intermittent. So that means that that contract is only from 1 day up to 6 months, and it is only for, you know, jobs that are not continuous in nature, but are seasonal and intermittent. Then we have another type of contract, which is termed temporary contracts. And temporary contracts, according to the law in Section 78, I believe, is a contract that is more than 1 month. It is not continuous, it is not intermittent and seasonal. And so it's a form of contract that is capped. It has specific beginning and end, and it is not continuous. So it is capped at a particular month. Oh, sorry, it is capped at a particular duration. All right, so it's not a contract that is carried on or that stays until retirement, but it has a definite beginning and end date. Okay, that's for temporary contracts. So often we'll say that they are contracts for project-based work, which means that, you know, projects have definitely beginning and end dates. And so those are the kind of contracts that basically cover, you know, those kinds of work. Then we have third-party contracts, and third-party contracts are, you know, contracts with or contracts that are not direct in terms of, does not have a direct relationship with the immediate employer, but the employer benefits from the labor services. So for example, outsourced employees are normally outsourced employees who are present on an employer's premises working would be seen as third party under third party contracts. And so that generally is, then you have other, you know, types of contracts like the apprenticeships and the traineeships. For example, national service is a type of employment contract, but it is a quasi traineeship arrangement, but it does not mean that there is no employment contract there. So there are such other types of contracts. For example, contracts for employees at sea would also be different. And then we have contracts for piecework and so on. So those are generally the types of contracts we can look at and we can talk about within our Ghanaian jurisdiction.
Thank you. That is quite elaborate on the very many types of hot contract. You touched briefly on service contract, but I would still want Wing Commander Samuel Alute to throw more light on what we mean when we say service contract, or would I rather say contract of service vis-a-vis contract for service, what the difference are, why is it important to separate a contract of service from contract for service. Ms. Alute, you can take us. I think
okay, thank you.
We'll be doing first names, and so
okay, sure. Yes, just Sam. Sam is fine with me.
I'll be referring to Mr. Javin as Senyo and Mrs. Vanderpoy as Jifa, and it makes a lot of things easier for us. So Sam, let's go.
Okay, yeah, thank you. So the contract of service is normally the employment contracts that we have. It claims it creates an employment relationship. I know the labor law governs the employment relationship as stated in the contract of service. The contract for service is also bound by that, But there was an ELA, Legislative Instrument 1833 of 2008, where it looked at how employment agencies could recruit, train, and bring them on board, like Senor said, as outsourced staff from an employment agency. So that is a contract for service. They come into the organization for a period of time, but they are not full-time staff of the organization. They might even wear, some of the corporate clothes and stuff, but they actually belong to the employment agency that sent them to the organization as an outsourced agency. So the fundamental difference is that one creates an employment relationship with the user organization where it's a contract of service, but a contract for service is just for them to come and provide services, and they belong to another organization.
Very well, thank you so much. Would you want to, okay, let me ask this direct question to you, Uncle Sam. Does the organization bear vicarious liability for these workers you are describing, particularly the ones who are on contract for service or for services?
Okay. The only area where there will be vicarious liability, it's in the area of occupational safety, where whatever injury happened to them was on your premises, or you did not provide the right equipment and tools for them. But in terms of they've not been paid their emoluments for X number of days, that should be addressed with the mother company. It doesn't come to the user agency. In fact, typical contracts for service relates to security personnel who are outsourced, so they come in from security companies to come and provide their services. And sometimes you hear the complaints that they've not been paid for X number of days. There is high attrition, and the organization might empathize with their situation, but there are no contractual obligations for the user company to intervene. So you cannot extend, that to the company because the service was provided in, say, company X, whilst you were seconded to, or you were sent in there by company Y. Those things you have to deal with. But if, for instance, sustained an injury or some mishap based on some, they didn't exercise the needed duty of care, then definitely, yes, they will have that responsibility to attend to the issue.
Very well, thank you. Now let me turn to Senor. Usually, people just avert their minds to, legislation, particularly in this case, the main law that regulates employer-employee relationship, Labor Act 651, and think that the Labor Act alone will be the basis for adjudication. What would you say is the legal framework, particularly as it influences adjudication on labor cases in our labor issues in our country? That's a way of contracting commitment on the part of the employer. In any case, commit the employer to doing A, B, C, or D, failure of which you can be liable for whatever. Can you throw some light on that to us, Senor?
Great. So, in terms of the contracts, and in this case, we're talking about contracts of service, you find that the contract becomes the primary document, reference document that would normally apply for either enforcement or for adjudication of disputes. Okay. Beyond the contract of employment, then comes the organization's policies, the HR policies. And the HR policies normally guide the processes for dealing with all employee-related matters in the organization. And that is the primary document out of which all other documents like the employee handbooks, like the contracts of employment themselves, and all other like conditions of service, and based on policies, the organization will also negotiate specific the union document, collective agreements, right? So these become the body of documents that would normally be, call it the second tier of consideration for adjudication purposes, or for reference, or for regulating the employment relationship. Then comes, of course, the Labor Act and its other ancillary laws. And so we have the Labor Act, and now we have we have three allies actually. So we have the National Labor Commission rules, which is LI 1822 of 2006. Then we have the labor regulations of 2007, LI 1833, which was passed by the minister. Then we have a domestic workers regulation, and that also has come to add to the allies. That was passed, I think it was just last year or so. So these then, of course, are apexed by the National Constitution, the 1992 Constitution, which all of these regulations are supposed to align with. And so this would be basically the generality of the, call it the immediate laws that would regulate the relationship. But of course, we have other ancillary laws that regulate aspects of the employment relationship. Like, for example, for pensions, we have the National Pensions Law, which regulates the SSNIT, or call it the pensions deductions and all that. So you have the three-tier pension scheme, the SSNIT, the first tier, the second and third tiers. Then you have, for disputes resolution, we have the ADR Act of 2010, Act 798, which regulates dispute resolution in the country, and which the Labor Act is subject to. So that also comes into the picture. We have the Factory, Shops and Offices Act, and we have other, little ancillary laws that help in regulating the employment relationship. But like I said, the labor law, the contract of employment, the conditions of service or collective agreements, the HR policies of the organization, and then the Labor Act. These are, and the allies, these are the general regulations that would apply when it comes to enforcing the agreements in the relationship, or resolving disputes when they occur.
Very well, thank you, Senor. So it is not all about, it is not in the Labor Act, so it's not binding on me. If you go contracting yourself or having a contract with the employee that says A, B, C, D, you are so binded by that contract as it carries the force of law. Thank you.
Jeff. Yeah. Let me just add that I think that in all of this, let me just add briefly that the absence of a written contract of employment, as defined a contract as, would not mean no contract of employment. So the absence of a written contract, as also a contract of employment may not be in writing. Okay, just to add that, so that we have a full view of it. So if we are going to enforce and we don't see all of these things, we don't see a contract of employment, we don't have conditions of service, we don't have HR policies written down in place, it does not mean there's no contract. The 1992 Constitution and the Labor Act and its allies and the ancillary laws will still kick in and be able to help in any form of enforcement or dispute resolution. Yeah.
All right. So just before you go, earlier this week, sometime Tuesday, an HR of a rather large organization in this country called me to tell me that beyond the employment letter, the single employment letter, the company doesn't have any other form of any elaborate contract involving the regulations of the employer and all of that, and that all they use is the Labor Act. Now, is that company disadvantaged in any way by not having a properly documented or drafted contract with its employees?
Yes, that's an interesting one. Let me read something to you in section 13 of the law. It's about written statement of particulars of contract of employment. So, subject to the terms and conditions of a contract of employment between an employer and a worker, the employer shall within 2 months after the commencement of the employment furnish the worker with written statements of the particulars of the main terms of the contract of employment in the form set out in Schedule 1 to this Act, signed by the employer and the worker. And the operative word there is shall. So giving just a simple letter of appointment does not wash these days. Indeed, this is a breach of the law if we do not offer or issue the main terms and particulars as set out in Schedule 1. And Schedule 1 has 11 items, 11 headline items based on which, or around which the relationship must be crafted. And so those must be developed into a main document for the signing of both parties. And that then would constitute the contract of employment. Now, if it is not available, the employer is disadvantaged in a lot of ways, because then the general application of law or provisions of law will come to apply, in which case the employer may say that, well, we don't have a policy on this. Well, then the law would be interpreted generally to protect the interests of both parties, and that often would not inure to the benefit of the employer, because in Section 8 of the law says that the employer has the right to develop policies. That means that the general provisions of the law does not cover every corner, nook and cranny of the employment relationship, and because of customized provisions of rules and regulations, it's important for the employer to now develop the policies to customize the general provisions of the labor law. If they don't do that, then the general provisions will apply to them, and it may not be very nice at all at that time. And so it is important that we do the policies, and we also flesh the contract as much as possible in accordance with Schedule 1 of the Labor Act, and then we'll be in compliance and we'll be fine.
Very well. Thank you for that rich knowledge shared with us. Jafar, do you have anything to add to this bit? The general legal framework that influence adjudication on labor cases, because like I mentioned, some people have read their minds only to the Labor Act, and once it is not in the Labor Act, I am not binded by any law to be. Meanwhile, you have signed a contract with your employees. Do you have any bit to add to it? Very briefly, we'll take that of Sam Alote, and then we go into the key issues, some very important areas of contract we need to address, just to be sure that the employer is protected enough.
Well, I think that Senor addressed everything regarding the documents that would generally govern an employment relationship in Ghana. I think he did. But in terms of the advantages of complying with the Labor Act, that is having a written agreement, I think another disadvantage to the employee is that the case law has said that if you want to enforce something, you have to show what the terms you are enforcing. Now, without that, as he said, you will be stuck with the general provisions, general decisions from the courts in relation to your employment. So it is important to have a policy, and then to state clearly what the rights of each party are. in the relationship.
Thank you. Sam, do you have anything to add to it, please?
Oh, yes, just in agreement with what Senyo said. For instance, there is a hierarchy of laws. There are subordinated laws. So your HR policies and provisions cannot override a regulation of the Minister for Employment and Labor Relations or the Act, nor the Constitution. So if you say that, okay, in your policies and procedures, you are doing summary dismissals, you are not giving people a fair hearing, definitely you are in breach of the law, because the supreme law of the land says that everybody deserves to be heard. So I think it would be very wrong to be very content with just the provisions of the Labor Act, because the Labor Act empowers the minister to issue legislative instruments from time to time to govern the employment relationship. And as they say, ignorance of the law is no excuse. It is your duty to know that you are complying with all the laws, because yours is a subordinated clause. I mean, it can be overridden by provisions in any of the laws higher in the hierarchy. So at least HR practitioners must be guided by this.
Very well, thank you. We will be taking a quick 1 minute break briefly, and when we return from the break, we'll be going into some detail and critical areas affecting contracting. Can a contract be varied by either party? Must it always be by consensus? What happens when you find yourself in times we are in now, natural disasters like COVID, and all of those issues? What do you do, force majeure? And all of those matters will be looked at when we return from the break. Many of you are sending in your questions. Yes, we'll be addressing all of them, but like we did announce at the beginning of the session, we would only read out your questions or take your questions for the resource persons at the tail end. And then we will be ending the session. So when we return from the 1 minute break or so, we will go into
Why do 93% of the world's leading multinationals companies prefer certified professionals? Because they tend to be more committed to higher standards and ethics and maintain an informed intercultural competency. Whether you are seeking to build a career or to upgrade your HR professional career, you need to get trained and certified at the HR Certification Center today. Our experience in training and certifying HR professionals is unparalleled. We are trusted to offer a comprehensive portfolio of advanced professional credentials for the HR professionals worldwide. And today, more than 500,000 HR professionals worldwide in 125 plus countries proudly maintain our credentials as a mark of higher professional distinction. HR Certification Center. Call or send a WhatsApp message to +233 244 822 855.
All right, thank you. So we want to go into some details after dealing with all of those preliminary areas. And let me remind our viewers and listeners that this is an exercise we intend to sustain. First Saturday of every month will be on. And so our next session will be on the 5th of June, and that will be on employee discipline. The following month, we'll look at workplace investigations. Following that will be managing interdictions and suspensions. We will look at leave management. That has become a big issue, whether the employer have the right to ask you to take leave at any time. I mean, as the lawyers would say, it is your right to go on leave or to take leave, but it is the employer's right to administer leave. We'll also be looking at managing redundancy. Senyo on our immediate past labor law masterclass platform did mention that several of you who have to go through redundancy in this COVID time, if you had consulted him, he would have, prescribed another vehicle that would be less expensive for the company to undertake rather than the redundancy you administered. So we are going to look at redundancy in general. Under which circumstances do you have to render redundancy? And so we would also be looking at collective agreements. We will look at office romance and sexual harassment. We will look at workman's compensation. I know that is a big issue. We'll look at dismissals. What does the law say about dismissals? Managing contract, fixed time contract staff and casuals, and then conducting fair termination. So as the months fold, we will be taking our time to look at this. Before I get into a few provisions in the contract that we must pay attention to, issues of non-compete agreement, issues of confidentiality, issues of non-solicitation provisions, ownership of intellectual properties, and all of that. I want you to generally tell us what you consider as the provisions of a contract. Typically, if you are drafting an employment contract, what are the areas that you want to be sure that are touched or covered, just so that the organization doesn't find itself at the wrong side of the law?
Thanks, Jeff. I think Senor mentioned them in the schedule, what the employment contract should have, which will be the minimum requirements. And I'd like to add that the Labor Act is the minimum requirement that an employer must satisfy. So whatever you are doing, it should go either above the provisions of the Labor Act, but you can't do less than what the obligations of the Labor Act prescribe. So under the Schedule 1 of the Labor Act, it says that you have to have a contract. The contract must state the working hours, the duties of the employees. It has to state the disciplinary processes that will be applied in the event of a misconduct. It has to have a grievance policy. You must have provisions on incapacity, whether you will pay sick pay. You have to have that provision as well in your employment contract. So it's when it comes to those, and then you have to add your pension provisions as well. So those are the standard clauses that you should at least have in every contract of employment. I have to say that sometimes for a lot of companies, they would have the grievance and the disciplinary policies in a separate document, which is the HR manuals, conditions of service, but it is still part of the employment terms, normally where you incorporate those terms in your contract. So if you don't have that in your contract, it doesn't mean that the contract is illegal. Once you can find it in another document, that should be satisfactory. So in relation to duties, we find that, and many people would have this in their employment contract, where the employment contract will say you will undertake any other duty that the employer may assign. That is a very, very general provision that should be avoided if possible, because the employment contract is an agreement between the parties, and it is for a provision of specific services. So for instance, an accountant is coming to do accounting services. If you have to assign him to something else, it has to be something that is associated or related to the terms of the employment. And so we will call these the core functions and also part of the fundamental terms of the contract. So when you want to vary this term, then you definitely need the consent of the other party. The implications for me and under the law also are that you change the position of somebody just because that provision empowers you to do so. And then an accountant is now performing a different professional service, something that he hasn't trained for. That employee will suffer in terms of performance. If you were to terminate that employee or put them on a PIP or demote them, whatever the consequences of non-performance are, there is a risk that the employee can challenge you that you vary the terms of my employment because those were not the core duties I was assigned to undertake on employment with the company. So normally the wording of that provision is something I think every employer and employee should note. It should be very clear that it is duties that are associated or related to the position. So for instance, in an accounting profession, they have different units, different things that each person does. It is easy for the skills to be transferred from one unit to the other within that profession, but it's impossible for an accountant to become a lawyer because they don't have that training. So that is for one part, that's for the duty issue. I think that is something that we, both employers and employees, need to take note of.
Right. Thank you. Before I get back to Senor, let me pick Sam's view on this. There are many instances where employers sometimes like to, if you may, contract themselves out of legislation. I want you to address issues of conflict between the contract, the law, collective agreements. I think Section 105 of the Labor Act seeks to speak to this. But I have seen in some companies employment contracts where the parties are supposed to be agreeing because the employer would have proposed it, the employee would have signed it off or agreed that an employee will take 12 working day leave per annum. And we know that the Labor Act states sacrosanctly in Section 20 that it shall be 15. I've seen in HR policy of companies that states that an employee have maybe 8 days sick leave in a year. So what do you say? Section 24, sick leave not to be computed as part of annual leave. The general issues of contracting yourself out of legislation. How does that fare? Yes, it might be a contract both parties have signed. Would it stand the test of law when there's an issue? Sam.
Okay, thank you very much, Jeff. You know, these breaches or infringements on people's rights that you summed up, they fall under what we call employment practice liabilities. That means it's going to be a pain to the organization if they should come before a court of competent jurisdiction, starting with the National Labour Commission. Because in the first place, as Jifa said, what has been set out in the Labor Act are minimum requirements. And there's a caveat that you cannot make the employee worse off. So you cannot go to eight days of leave and the like. You have to be mindful of the fact that the employee have rights as well as they have duties. And if it's a unionized organization, definitely any employment practice liability will be flagged, and the National Labour Commission would be the probably court of first instance. And what is likely going to happen is that you are in breach to start with, and you cannot justify why you've breached the law. Definitely, if you, for some reason, you cannot give the minimum, it cannot be negotiated. Secondly, this forfeiture of leave, I think Section 30 of the Labor Act says that any agreement for the forfeiture of leave is void. I like the wording there. It says an agreement. So yes, you agreed with the staff, and but it does not talk to the spirit and letter of the act. So even though you can come flagging the employee's signature that, oh, he agreed, we talked about it, and he said he was fine with it, you'll still be in breach. So it's not good to cut corners. I say, like you said, managing yourself out of legislation, because ignorance of the law is no excuse, and a breach of the law is a breach. And most times people get surprised. They say the courts are sympathetic to the employee. There are instances when the employer falls on his own sword. There are things he's promised, he's reneged on those promises, and he expects to get away with it. The long arm of the law will definitely reach out and grab.
Very well. Thank you so much, Sam. Senor, let me speak to, or kindly help us speak to issues of liabilities, particularly in third-party employment or engagement. So I know of cases where an employer who probably, let me say the beneficiary company, an estate company where security officers were detailed from, as third-party employment from another organization. The beneficiary organization fails to, grant them, would I say, a break in between their work. Well, it's not my business. I just want you to secure my property over here. In the event that these employees, who are the security officers here, take the organization on, where does liability lie? Their mother employer or the secondary employer, who in this case is the beneficiary organization. There are situations where in this COVID, for instance, an organization instructed that all its employees undergo COVID tests before being admitted to the office premises. Who bears the cost? The primary employer, the beneficiary organization. Play around these things for the benefit of our listeners and viewers.
Okay, so instead of just jumping into the oil that you have cooked, I would just like to say that some of these things are clarified better in the service agreement between the, call it the client and the agent, the service provider. So, however, if there is a breach, the primary responsibility, okay, or liability would go to the employer, the actual employer of the employees or the workers. But this is where it gets interesting. Now, because the client or the call it the beneficiary employer is benefiting directly from the labor services, and these breaches are occurring within their context or within their ambit, they are deemed to be aware or ought to be aware, and therefore can be accused of aiding the breach. That way, it is easy to rope them in and hold them partly responsible for the breaches as well, because being the beneficiaries of the labor and the people with the powers to be able to have stopped it or done something about it, and they did not, they may then be held like, partially or jointly liable for the breach. Now, but normally the agent is not as financially, endowed as the employer, call it the clients, right? So the organization who is benefiting from the third party contract. So then they would rather go after them than going after the agents who normally may not have the financial capacity to fully meet the liabilities. And so, however it works, the beneficiary organization has a duty of care to the employees as well, especially because they are benefiting from their labor. And that's generally what I can say. I would also say that there was an issue with Tigo some time ago where the agency, I think it was Reliance or Renaissance, something, an agency, forwarded or issued a memo to all employees that employees in their contract arrangement or outsourced workers under them cannot get pregnant while they are in employment. And it became a huge issue. And Tigo had to quickly step in, disassociate themselves from that, memo that was issued and from that particular policy, and sanctioned, the agency, the labor outsourcing agency, for breaching the rights of the workers and also breaching the terms of the service contract. You see, because the service contract will definitely say that you have to obey all the labor, regulations and laws of the land. And so these are some of the things that organizations should look at. The fact that you have, and especially like the banks and insurance companies and the security companies who are using like third-party contractors, they need to be aware that if there are breaches, they can be held accountable. They can be held accountable or liable jointly. And so they have to use their powers to ensure that they protect the interests of the workers, as the case may be.
Very well, thank you. Jifa, let's have you comment on this. Some key terms usually that we find in contracts, i.e. you can throw light on confidentiality. We'll be happy if you emphasize in non-compete agreement and non-solicitation provisions. And then you can also touch a bit on force majeure to us. Jifa.
Okay, so these provisions are contractual provisions. They are not mandated by the Labor Act. That's the first thing. But an employer is is entitled to protect its business interests. And so normally they would put in these provisions, for instance, confidentiality. You can't disclose company information, confidential information of the company to third parties, either without consent or to use it for your own personal use, unless, of course, a court has required you to provide that information. So that is the bit about confidential information. I think the main issue, which normally comes up with confidential information, is non-solicitation and non-compete. Now, these provisions are because you, as an employee, have been able to access certain information, which is key to the company's business, so much that you will be prohibited from engaging in business that is similar to your employers when you terminate the employment. That's if you resign from the employment. That is the non-compete provisions. Then the non-solicitation is normally prohibiting you from either inducing other employees of the company from which you have left to come and join you to work, or trying to solicit their business clients to whatever business that you are doing. Now, the issue with this is that they are called restrictive trade clauses. The public policy supports competition. That is, every man has the right to exercise his trade. So if any such clause is put in an employment contract, what the law is looking out for is to check whether, one, are you protecting a specific legitimate interest? It's not as if to say a security man in a company, for instance, who's probably never even entered the building, and then on termination or on his employment contract to have a provision that says he can't work for a similar company. So maybe a security company the security officer will not be able to work for Stanbic Bank, and also work for Commercial Bank. That security officer has not had any access to any information which would be of any use to him, or which he can provide to his new employers, which will be disadvantageous to the current employer, to his former employer. So that is what the law is looking out for. Now, what interest are you protecting? Exactly why are you restricting this person from engaging in a certain business? If there's no legitimate interest to protect, the law will not enforce that provision that you have put in, the non-compete or the non-solicitation provision. In addition, if that provision is too wide, so the person works in Ghana, but you have prohibited him from working anywhere in the world in a company that is similar to yours. You have also prohibited him from engaging in any related or associated business for 5 years, 10 years. How will the person be expected to survive? Because that is their trade. And if they cannot exercise it, then the law will say, no, this is anti-competitive. We cannot enforce this because you are prohibiting somebody from earning their living. So generally, prohibitive terms like the non-compete and the non-solicitation provisions are only enforced when they are reasonable, so it depends, and it's on a case-by-case basis. So if you work in an international company, let's say Coca-Cola, and they have similar, so maybe somebody in Coca-Cola can work around the world, then it will be reasonable to prevent that person from working in another entity, let's say Pepsi, in the world, because maybe the person is a key employee in Coca-Cola Ghana, is privy to information available to the whole Coca-Cola group, and will be able to provide that information to third parties or competitors to the disadvantage of the former employer. So that's the issue on the non-compete and the non-solicitation. So if you're an employer and you are providing such a term, you have to be sure who you are giving this term to. It shouldn't be a standard clause for every contract. It should depend on the level of the employee, the access of information they are privy to, and how they will earn their living afterwards. In relation to the issue of force majeure you mentioned, so a contract is agreed between the parties, and then an event occurs that prevents the parties from performing the contract as it was originally intended. So generally, the issue of frustration. So something has occurred which has frustrated the contract, and therefore the contract is totally different from what it was meant to be. And the COVID was the perfect example where we were employed to work on site. Well, for those companies that worked on site, we were employed to go into an office, work, and then come home. Now there was COVID, and let's say those in the exploitative industry, they could not work and they were at home. The contract has changed. What can the employer do to manage that situation? I mean, apart from the termination and the redundancy options, if the employment contract had a provision on force majeure, which allowed the parties to suspend their obligations for some time whilst the event was in existence, and then to come back to the terms when the issue abated, then at least some people will have their employment after a certain period. But now, as we know it, a lot of people have been sent home. Well, COVID is still not over, but it should be sometime with the vaccines and all. And those employees will never go back to their former employer anymore. When an employment contract has that, it allows the parties all to be ready that this event can occur. So force majeure provisions are normally events that are not comprehended by the parties at the time they are contracted, and it normally would have natural disasters, epidemics or pandemics of this nature. We will have wars, we would have earthquakes and so on, which would have disrupted the contract completely. Now, with those ones, you can't just say, okay, the contract ended, there was war, and so it's force majeure. No, your employment contract has to specifically state that an event occurred, and this event, on the occurrence of this event, we would not perform the contract until the event abates. But with frustration, with frustration is that issue of law. You go to court and tell the court this has happened, and the parties will say, well, the court will say, well, it is true that the contract is no longer possible to be performed, and so they will just set the contract aside. So those are the two things, and the way to manage it, I think, the frustration issue is rather to have a force majeure clause.
Very well. Thank you for educating us quite extensively on that. Let's speak the thoughts of Sam. Under what circumstances can the employer vary the terms of the contract? Almost unilaterally, we have seen many employers do that in this COVID. And I do know that COVID, for instance, should not lay aside the law. And without novation clauses, employers have unilaterally varied terms of contract. Under what circumstances generally will an employer or will the parties be able to vary terms of the original contract as signed? Sam.
Yeah, thanks, Jeff. I think that first of all, the contract was an agreement between two parties with the intention of creating legal relations. So definitely it will be wrong for one party to unilaterally vary the contract. However, in the Labor Act, there are the duties and rights of the employee and duties and rights of the employer. What the employer needs to do for the sustenance of the business, for its survivability, should be discussed with the employees and agreed that this is a way we have to go in the light of some contingency that has come up, that's the force majeure, as Jifa mentioned. And based on that, I believe that some common ground can be found. You know, there have been organizations where people have taken pay cuts and the like to ensure that the company survives, because the heading in the Labor Act says protection of employment. You know, we have to first protect the employment so the employment relationship can exist. Now, the unilateral piece, I don't think the employer can extend that right, the right to vary the job restructure and the like, you know, without bringing the employee on board. I know, like you rightly said, in some instances as well, it's a take it or leave it. Well, if the contract is to be abrogated because it's been frustrated, definitely if the there's a collective agreement and there are some redundancy packages to be paid, then definitely you are now terminating the employment relationship based on provisions that have been agreed. But to do it unilaterally, I think is going to create a lot of trouble for the organization. Now, in the national crisis that we have, the pandemic, I believe that everybody was empathetic to it, and people kind of said, "Look, it's a bad day. Let's wait for better days ahead." If people want to take the organizations on, in the sense that the actions were unilateral, I'm sure the National Labour Commission would sit to look at the issues involved.
Very well, thank you, Sam. Before we read out the comments of our viewers and listeners, and I encourage you, if you have a question, kindly get into the chat box and put your question there, as many have done already. In the next couple of minutes, I'll be reading out those questions, and probably that will expand the issues some more. But in a few minutes, we should be bringing this session to an end. The first session is just about ending, which is the panel discussion. Your questions probably will bring out a lot more issues. But let's pick the thoughts of Senyo on fellow. A lot of the organizations in this COVID time have had to use the vehicle of fellow. And some of them, I must confess, my observation is that they haven't gone about it quite well. And if their employees had taken them on, they could be found wanting. Senor, can you educate us on the legal principle of fellow as a vehicle an employer could use in times like this? Senor, you are muted. Kindly unmute yourself, sir.
Sorry.
That's okay.
My views about fellow is that it's a legal principle where, in the event that both parties or one party is, normally it's both parties, are unable, okay, to meet the requirements of their obligations under the contract, then both may agree under the circumstances that the contract should be stood down or should be frozen until better days where, like Uncle Sam says, better days where then things can come back to normal, and then where a party is able to now meet their obligations, or the parties are able to now act under the contract, they are then able to do so. So for me, basically, it's about freezing the contract until the point where the parties are ready to either terminate the contract, end the contract, or continue the contract in one form or the other. But during a fellow, the agreement is that all the obligations under the contract would be frozen for the meantime, for another more conducive time. You are right that some organizations have not really applied it well. It is a matter of negotiation and consultations. And then while we are talking about contracts of employment, we need to remember that it's a relationship. The employment relationship is not a contract for goods or something. It has to do with humans. So consultation is key. So where it is agreed, then there are no issues. But where it is imposed, then it can be challenged. And as Auntie Jifa has said, you would need to prove in court that there has been indeed a frustration. Because you see, some organizations made money during COVID, a lot of money. And some organizations also collapsed. And some, suffered greatly, right? So it is based on the specific facts and the specific circumstances of the situation that a court or the National Labour Commission will look at to say that, okay, then you are justified or not. But it is not good practice in employment relations to impose things on the other party. That normally is always a recipe for disaster. Yeah.
Right, thank you. Folks, we would have continued this discussion, especially how our various contracts affect other employee issues as managing leave, disciplinary issues, terminations, and what have you. But because we have dedicated times for discussing these other topics, we would want to bring the panel discussion to an end here. The session is not ended. We want to now read out your specific challenges and questions pertaining to contracting for our able resource persons to respond to. So I read the first one coming from Sydney. Sydney says, I want to find out with the outsourced staff belonging to, say, company X, but are working on your premises. It is very, very difficult to handle them in cases of freebies. Your company is sharing T-shirts for, let's say, May Day, but they don't get bonuses. They don't get giving out food, and you don't give them, among other things. They start to grumble. How do you handle these situations? I think fundamentally what we want to say is whether this third-party employees actually deserve some of these benefits that the employee gives out or not. Now, can we have any of the resource persons take up this?
Okay, so I'll go.
Yeah.
Those employees are not entitled to the freebies from the company.
Okay.
The company may give it to them, but even in providing those things, the company has to be cautious, because as you continue to do that and to provide other benefits that you would normally provide to your employees and so on, you are holding out these employees as yours. So when there's an issue in court, which is what Senyo mentioned, that they want to, they would like to get damages from the person with the deeper pockets, which is always the user company. Of course, they would go to court and say, you've put us on your payroll. You call us your employees. We have your call cards. We do all of these things that show that we are employees. We are under your control anyway. So why are we not your employees? Why should we not be treated as such? And the courts will look at the substance of the relationship. And that is one of the issues that always comes up in relation to outsourced employees working on the same premises as the permanent or whatever type of employment the company has with its employees. So it has to be managed properly. If it is possible, the company can have those employees sign an agreement that specifically states that any enjoyment of any other benefit that's not under their terms of employment with the employment agency, which is provided by the company, will not or does not create any employment or legal relationship between them. And it will be necessary that each time they are getting those benefits, an email is sent out with it to reinforce that fact, so that there will be no misunderstanding of the position of those employees.
Very well, thank you. Let me get back to Senyo before I bring in Ankesam. Senyo, someone is asking, can you please clarify the doctrine of co-employment and vicarious liability and how it applies under the labor laws of Ghana? Co-employment, vicarious liability, how does it apply? Senyo, once again, please do remember to unmute yourself, sir. I think that the twins are.
I think when I look at Jifa, then I forget. I start speaking, and I forget to unmute. Anyways, you see that the doctrine of co-employment will only apply based on specific provisions of contracts, okay, interdependence, okay. So those provisions are the ones that are going to apply, and those provisions normally would indicate who is responsible for what, and that then will make it easy to determine who is liable for what. As for vicarious liability, the principles of vicarious liability will apply where it is evident that the other party knew and partook in it, benefited, or to a large extent was aware of the situation whatever it is, either a breach or whatever, and didn't do anything about it, or somehow ordered it or benefited from it, and so the principles of vicarious liability would apply evenly without any much exceptions. But what would really be necessary would be the document or the contract that regulates the whatever is termed as the co-employment. Yeah.
Very well. Thank you. Let's have Sam. Someone is asking, I'm reading word for word. The Labor Act supersedes employment contract of a given company, right? I'm reading word for word from the person. Eraja Yeboah is asking. The Labor Act supersedes employment contract of a given company, right? Sam?
Yes, that's correct. It's subordinate legislation. The Labor Act stands firm, from which regulations derive, from which your specific organizations, policies, and procedures. And that is why the general rule of thumb is that don't make the employer worse off. At least let the Labor Act provisions for leave, etc., be the baseline, like maternity leave. You can give more, but you can't give less.
Maybe except for specific provisions like Section 17 against 19, where you are supposed to be given 1 month notice of pay in lieu and vice versa, except when Section 19 says that when there are express agreements between the employer and the employee, but there's a caveat there where it is more beneficial to the worker. So with that, you can tell that the employer and the employee's agreement tend to then supersede the provision of the Act. Sam, would you agree to that?
Yes, you see, you are operating within the caveat.
Yeah.
So you are not giving the minimum. You are now doing more than the minimum. And the law has empowered you to do that. In fact, it is not a fight. The law said don't go below, say, 18 days. But if you want to give 40 days of leave, that's fine. I mean, the law is happy with it, provided your operational exigencies can accommodate that. You see, where the law protects the rights of the individual is where the people would want to take advantage of the employer or vice versa. That's why the duties and rights have been spelled out. Yes, you have certain things that rest within your mandate to do. You can vary, for instance, the engagement, the business lines, and so on. But of course, you also have a duty to the worker to train him. So it's kind of a balancing act. Duties and responsibilities are in a balance to ensure that the business survives. So is the protection of the business and the protection of the rights of the employer, the protection of the rights of the employee. That is what the Labor Act seeks to do. But when it comes to issues of your people management framework, how do you want to retain your staff? If you think that you have to give them more days leave, you have to give them more maternity days as a way of a retention strategy, the Labor Act doesn't frown on that, provided your business can sustain it.
Very well, thank you. We also have listeners following us on Facebook, and these two are coming from our Facebook followers or viewers. And this goes to Jifa. How can one freeze a contract legally?
I think that's what I mentioned, and the employment term is fellow that Senyo mentioned. So you legally freeze is when you have force majeure provisions which allow you to hold the contract in abeyance or suspend it until whatever issue that is preventing it from being performed abates. So that is the way to do it.
Right, thank you. Senyo, one wants to know from you, can an organization absorb an exceptionally good third-party employee to become a full-fledged employee of the beneficiary company? And if so, what will be the implications? Senyo, please activate your microphone. Jifa disappeared.
This one, it wasn't Jifa.
Yes, sir.
Okay, so that is also an area of the relationship that is regulated by the service contracts, right? I've seen some service contracts that ensure that whenever the beneficiary organization poaches, right, they outsource the employee, then they pay some commission to the outsource agency. So yes, these things are regulated. However, as usual, if it is done unilaterally, the outsource agency, if really they have what it takes, they will, can still sue for some compensation that you have stolen their, because you see there are expenses in, and there are expenses in recruiting people and training them and bringing them to a particular operating capacity or competency. And where somebody just comes to take them away, it is a loss, as we know. So they can always sue for, but as to whether an outsource agency would sue because they have a contract they want to retain, that is the balance. But in any case, we need to ensure that these things are taken care of in the service contract between the service provider and the beneficiary company, so that we don't have these things happening.
All right. Yeah. Thank you so much. Sam, an online interview was organized and one person was successful. An offer was made to the successful candidate. At the point of acceptance, she made it known to the employer that she would soon go on her maternity leave due to her pregnancy. Now, can the employer withdraw the offer because the candidate is needed to fill the position as soon as possible, and break may not be helpful to the organization? So at the point of engagement, you realize, or an employee, a prospective employee, discloses to you that she is pregnant and will soon be due for leave. An employer thinks that, no, I need somebody who can be in this role per the demands of the role, and we cannot afford a 3-month maternity leave at this initial stage. Can you refuse the engagement or terminate the appointment if it has been contracted already? If you can play around the issues to us, sir.
Okay, I would
your presentation to cover these whole issues of pregnancy. At the time of engagement, the employer isn't aware, he didn't ask for, the employee did not disclose. Later we realize, can we let you go? There are so many issues that come with this kind of issues. At the point of engagement, we realize that a candidate or a new employee is pregnant.
Yeah, thanks, Jeff. This is a very tricky one, and I would share some thoughts, and maybe Senyo and Jifa can give their views. You know, there is a particular role that, if I understood the scenario, that the applicant is being recruited to fill, and the suitability of the role requires that you go into immediate deployment. Now, if you are not able to go into immediate deployment, then that in a way frustrates the contract, because you have to go, and we should be very mindful. We are not looking at, of course, people will say that then you've discriminated against her, but let's not even situate it in pregnancy. Let's even assume that there was an accident and the person has been hospitalized and the person can't go into immediate deployment. What do we do? So my view is that, yes, you cannot discharge the requirements of the contract. And I think that should be brought to your attention. And if it is a critical requirement that somebody should go immediately, then of course they have to find somebody else to go. If you were the top of the range in terms of the applicants who applied the rank and you were the top, and they would want to consider you for another role, you know, it's happened in an organization I was in before. We allowed them to go and have their babies and come back, you know, but it's because the roles they were going to fill was not that critical. So we had the, let me say, the luxury of time to wait for them to go because they were very brilliant. We wanted to keep them. But assuming it is some position that we have to send somebody to immediately, then definitely we have to bring to the applicant's attention that we cannot proceed with the contract because she will have to, her circumstances do not allow us to go ahead. But I'd like to hear the views of my colleagues. Mr. Moderator, would you?
I'll let you go first. She's a lawyer and she's a woman.
No, Mr. Alote is also a lawyer. In fact, I was going to play devil's.
Particularly to respond to this as a woman, a female.
No,
lawyer.
I was actually going to play devil's advocate and ask Mr. Alote that. So what if the employee is able to start the work, but will have to go on maternity leave a month after? So she will be available, but after a certain period, she will not be available. Because the scenario you create.
Am I picking up divergent opinion on the issue?
No, I totally agree with Mr. Alote, but what I am thinking is that with that particular issue, it means that it has been made clear to the employee at the interviews and in the recruitment process that the role is urgent, the role is critical. And so I think it would have been at that point where the employee would have to put in the information, also disclose the information of the pregnancy. But if they went through the process normally, yes, we need somebody, and they, all these application forms to have, when will you be available? And then you probably add a month's notice, say you are entitled to give your employer a month's notice. After that, you'll be available. And indeed, the employee would be available, but maybe a month or 2, 3 after, they would have to go back and have a baby. Then I think we'll start going into the discrimination bit. I don't know what Mr. Alote and Senyo think. All
right.
Okay.
Yeah, is there any dissenting view from Senyo?
No. I think that the only tricky part there is therefore the drafting of the job descriptions and also how we advertise the position. And for me, like I keep saying, consultation is very important. So we need to call the person in and make the person understand that we may not be able to go on with you because of A, B, C, D, and E. And we should be able to prove that truly the role is such critical to the point where the person's unavailability would adversely affect the job, okay? So for me, I think that is an issue of availability, and it's an issue of whether we have evidence to show truly in the job description that the issue of fitness for work is affected adversely by the pregnancy. Otherwise, then it will be discrimination. So it depends on the circumstances.
Yes, we have just about a few minutes to end the session. I will not be able to read all the questions out, but I will pick a few of them, and those whose questions will not have been answered or read out would forgive us, but we will have another platform on another day, as I mentioned. Let me pick, Senyo, I was going to direct these questions substantively to you, like this substantive question to you, other than just the opinion you are having on the question I directed at Alote. So can an employer limit the number of paid sick leave? Can the employer limit the number of paid sick leave? I wonder whether you are even supposed to be having a number first and foremost, but there's a follow-up.
Exactly.
So, for example, if the employee is on sick leave for say 6 months to 1 year, how should this be handled by the employer? I mean, that is clearer. 6 months.
Yeah.
1 year.
Yeah. So you see, it's very open when it comes to handling long-term illness. The law does not cap sick leave. And so that has to be regulated by policy. And this is one of the clear situations where there is no policy, an employer can get into trouble. I've seen policies that have capped sick leave, and I thought it very preposterous because it cannot be. It's just like telling somebody that you are allowed to only get sick 10 days in a year, and nobody is God, right? So it really does not make sense. How do you handle it? By policy, Traditionally, organizations will give tiered durations of taking care of the person's salary until they medically board the person and declare the person unfit and then terminate on grounds of unfair termination. But there's a good practice that normally I subscribe to from New Zealand, which says that after reasonable time, which is a duration between 3 months to 6 months, the employer may ask the employee to take a medical fitness for work examination. And once the outcome comes and the employee can recover within the next 6 months, which is a reasonable time, then they'll be kept on and then you recover and continue work. But if the employee cannot recover within reasonable time, then they are terminated on grounds of ill health with some medical compensation. So generally, that is how it can be handled, but it has to be handled by policy.
Very well, thank you.
Jeff,
Sam,
may I come in?
Yes, you can come, please.
Sorry, Sam. I think this issue of sick leave and sick pay is always confused. So when you look at the schedule said you have to have provisions on how to deal with incapacity. Then it says, and sick pay, if any. So it's not as if an employer is mandated to provide sick pay, but it can. But when it does, that's what it will limit. But the sick leave, it cannot limit. You know, so you can have, and which is the policy that Senyo has talked about. There is, in fact, a Ghanaian case on that with respect to one of these gold companies where the employee got sick. And so the courts also use the same principle that Senyo mentioned, that's for reasonable time. If within a reasonable period, the employee cannot come to work, then they can be terminated. And the Labor Act does provide for termination due to disability or ill health. So if the employee is terminated, you just do that within reasonable time. When I am doing employment contracts, I would normally say to an employer that 1 month is not reasonable time. If the person has malaria, they will be away for 2 weeks. They could have typhoid, and they could take another month. That's such a common disease that you can't say that it's a reasonable period. It should be a period that it will not, the absence of the employee will affect the business, you know. So we always have to differentiate between the sick pay and sick leave, what the provisions on the law say on sick leave, which is not capped, but the sick pay is open, you know. Yes.
Okay, yeah, Jafar, thank you. To the extent that we have a full session on leave administration, we want to stand this question for. We'll look at, general annual leave. We'll look at encashment of leave, whether leave can be rolled over, under which circumstances. We'll look at maternity leave and sick leave and all of those from sections 20 to 31 as provided for in our law. Somebody want to know from you, is an employee obliged to give notice before resigning during probationary period? And let me say vice versa. Is the employer also obliged to provide notice and reason if he has to relieve you of your duties during probationary period? The one asking the question is asking on the part of the employee, but I'm also adding the bit of, can the employer also be allowed to let you go without prior notice and reason during probation?
Yes, the appointment letter would indicate the notice period in it, which says that you have to give a month's notice, sometimes a month, or depending on your position in the organization, some can be as much as 3 months notice of your resignation because of the type of job you are doing, the critical nature. So it goes both ways. That's the notice or in lieu of notice. Now, during the probationary period, when people get the cultural shock and they don't like the organization, they just walk away. They don't come back. And at that point, you want to know, do you go running after them to come? You don't even have, they've not even done, what do you call it, any contributions to PF and so on that you can fall on. They've not been confirmed as full-time employees. So talking practically, you don't go chasing them. It will be out of place to say, you left your employment without giving notice. So we are coming to take the 1 month salary from you in lieu of notice. Practically, you don't do that. But if you want to terminate, it is believe that the onus is on the employer to let the employee know that, yes, he has made some sacrifices, he's left his organization, he's come to work for you. You give him cause why you think that the employment relationship must be abrogated, and give him time to go find something to do. So, and in most instances, they look at the sympathy goes to the employee, because he's now going to, fend for a living whilst your organization is still intact.
Right, thank you. Originally, we are scheduled to close at 5:30. It's a minute to 5:30, but due to the number of questions here, I want to plead that we do just 15 minutes. So we'll close at 5:45. It doesn't matter where we would have gotten to. By 5:45, 15 minutes behind our schedule, we would bring the whole session to an end. Senor, someone is asking you specifically, except the person is not being fair to you. It says that are expert workers expected to have local employment contract upon commencement of work in Ghana? And then the person is now giving the answer. I think yes, if you know why you ask. Now, please educate us on this. Thank you. So let's ignore the person's answer and listen to you. Now, Paul, don't feel bad. That is not to say we are the expert and you know nothing. But I thought that if you are asking a question, you will want to be fair to the resource person to respond instead of trying to answer to yourself. All right, Senor, let's go. Are experts supposed to be having local contracts, knowing that they are working in Ghana?
Okay, so in international HRM, there are always two contracts, right? There is the primary contract and the secondary contract. The primary contract would normally be the specific contract of employment between the parties using the, call it the not the host country, but there's a term they use for it. But let's say headquarters issues a contract, right? Okay, for the expert. So that would have its own structures and its law, the national law, the country based on which the contract is drafted. And normally for standard contracts, it's always in it. There's a provision that states the country based on which the law, the contract applies, the law of the nation which applies. Then there's the secondary part of the contracting where the immediate host country labor regulations become applicable. And so even though they may have a primary contract from headquarters, they'll have to work on their employment relationship using the host country call it municipal laws, regulations on labor. And so it is these two that balanced would regulate the contract. But your home country laws cannot supersede the host country laws, because that is where you are actually practicing the employment relationship. And also you cannot throw away your home country laws from headquarters or the ones that regulate the relationship and depend solely on the host country laws. But this is how it works. It is always a fact that the issuer of the contract can decide the country based on which laws should apply to the contract. And that normally ends the matter. But there will still be, call it virtual ancillary strings of laws that will be dragging the relationship here and there. But the primary law would state which country's law should apply. And that is a tricky one that normally comes with international employment contracting. Yeah.
Very well, thank you. Some of you are also sending in questions that are not, direct contract questions, because we will be having different sessions on employee discipline and, for that matter, managing leave and all of that. we will not be able to take your questions today. And also we want to save the time. But someone is asking a follow-up on the pregnancy issue. Ordinarily, I wouldn't have taken the question, except that it's too much a concern to people. It said in case where an employer does not do due diligence and employs a woman who turns out to be pregnant and has to go maternity leave before the end of probationary period, can they be terminated or not? Now, let me ask this. Now, whose responsibility is to find out whether a candidate is pregnant? Is it the employer who must make a specific request, must ask that the candidate indicates her status, or the onus lies on the candidate to declare that she is pregnant? Just that bit of it, and then we go on to other questions.
You see, we are walking a thin line, in my view. It's so thin that if you move a bit to the right, you are going into discrimination. And if you go a bit to the left, you may not be protecting the interests of. I'm sure that now let me put on my maybe arbitrator cap. In my opinion, it would be for parties to convince me that the employee is fit to do the job immediately as is available, beyond which the employer can decide to give room. But otherwise, it is very difficult to answer your question to say who is responsible. The fact that you did not disclose and the fact that I didn't know, okay, does not really matter. Indeed, if I had sought to know and you ended up not getting a job, you can sue me for, taking the decision based on your gender and the issue of your pregnancy. So that would not be an area I would dwell on, but I would say that, look, talk to each other, make sure that the employees' health is protected, the employee's interest is protected in whatever the decision the employer takes. So if you want to insist that the employee should work, when the employee really, the condition is such that the job can harm her, then again, you're opening up yourself to a lawsuit, because if something happens to the employee, their dependents or their guardians can come and sue you and say that you knew the person was pregnant and you still allowed the person to work. So it's a thin line. I would be interested in hearing Jifa on this one.
Jifa, you can come, please.
I agree on most of what you have said. My only issue is about this, the sickness and fitness to work bit, because really, if it is an office job, women work till 9 months. Well, I worked till 9 months and went to deliver the next week, and a lot of people do it. So if it is if it is a hazardous environment, then that issue will come up. But really, if it is an employment where the person's health will not be affected and the pregnancy is a regular, normal pregnancy without any complications, it will be very difficult to go on that fitness to work argument, and so that will be the difficulty I think that may arise there.
Yes, right. And I agree. I agree
Jeff,
with that.
Okay.
Yeah. Sam, you can come after quit. You
yeah. Okay. So I want to bring out the American doctrine of reasonable accommodation. I believe that it applies in general HR situations. So in the earlier statement, Jifa asked, what if the pregnancy does not hamper, the work that the lady is supposed to perform? And the doctrine of reasonable accommodation says that the onus is on the employer for any form of disability, reason for which people cannot work, to make that reasonable accommodation. So if the pregnant lady can do a substantial part of the work, then the portions that she cannot do, the organization must accommodate her because she's fit, she's qualified to do it. And her condition is temporary. I don't think anybody goes into pregnancy mode for a lifetime. So that is where the doctor is coming from. The temporary nature of her condition requires that reasonable accommodation be made. Now, the other thing you should realize is that the Labor Act specifically talks about employment of women who are expecting. And it will not be fair if we are treating them, you know, like very normal people. Someone mentioned due diligence. Let me tell you for a fact, some ladies in the first 3 months don't even know they're pregnant. I'm not a lady, but from literature, authoritative literature. So what due diligence are you doing before you employ? No, it comes to you. It comes to her even as a surprise. And so the doctrine of reasonable accommodation, I think, is a guiding principle. What can you do to help? That should guide HR practitioners.
So Sam, I had a call from an HR manager of one of the large companies in Ghana. They had engaged about 150 national service personnel, as in 150 of them were females. And on medicals, it came out that about 60 of the ladies were pregnant. Now, 32 of the 60 were not aware they were pregnant.
Due diligence.
They were surprised by the result. Now, someone wants to know from you, how legal is it for an employer to make it mandatory for all staff to take COVID vaccine and submit the result, to keep their their employment, if I may say so? Yes. How legal will that be? I know it's a very dicey area.
Yeah, If you I've forgotten the exact section. I don't have the labor act with me.
118.
118. Thank you. So
that it's supposed to be at the expense of the employee. Yes. So go ahead.
The employer has a duty backed by law to keep the workplace safe.
Yeah.
And if we have a situation like the COVID-19, a pandemic with a high mortality rate, and one of the ways of ensuring that you don't have contamination of the workplace by other people is that people are subjected to a test to know those who go into isolation and so on. I think it's a legitimate business requirement. In my workplace, the issue came up. Then we said, well, it has become a condition for your continued employment because we cannot risk your exercise of your rights should not disenfranchise others to exercise their rights. You also have the right to a safe work environment. So eventually we had to do some dialogue to get buy-in for people to realize that we are talking about life and death issues here. And yes, much as we are not going to, we are trying to minimize the stigmatization, we took everybody through the test. Because it is a duty of the employer to keep the workplace safe. And an employee can withdraw himself from the employer's premises if he considered it to be unsafe.
But what do you say about the bit of at the expense of the employee? If you are the beneficiary organization, why should it be at the expense of the employee?
I don't agree with it being at the expense of the employee because it's not the employee who is to, the onus is not on the employee to keep the workplace safe. I mean, in the Labor Act, it is the employer's responsibility. So he should bear the cost. If I have to take a vaccine, the employer should bear the cost. I'm not to bear the cost. You see, but of course, people dodge when they look at the financial implications, then they try to, maneuver.
Right. I'll pose the last question at Senyo. After that, I'll take your final thoughts on contracting, and then we'll bring the session to an end. Our listeners and viewers, I do admit there are still more than 40 questions we are unable to attend to because of the constraints of time. Let me pose this final question at Senyo, after which we'll take a final thoughts from all our panelists, and then we'll bring the session to an end. The person asked, can a construction firm whose projects are time-bound, seasonal, and for that matter, based on availability of government funds, offer contract for employment for their laborers and temporary staff and not pay their social security? How long can you hire a laborer according to the law, the labor law, and are you obliged to pay their social security contribution?
Yeah, so let me just say that the social security laws do not apply apply to only special cases. They apply to any worker. So any worker in any form and under any contract. So even if you employ casual workers, you're supposed to pay their SSNIT. That one is conk. Let's put it aside. But you see, the contract for service approach to employment basically is employing people as independent contractors. You see, so employing them as independent contractors shows some level of skill and some peculiarity to the service they are coming to provide. But if you are going to employ numbers, a lot of people under one roof to come and undertake some continuous services or quasi-continuous services, it will not be reasonable to use contract for employment. Under those circumstances, SSNIT will come at you and say that you are employing people, but you are hiding, from the SSNIT law. So they will force you to pay SSNIT for the workers. And I've had to deal with one of the insurance companies on this particular matter. So based on the number of workers you'll be employing like that, the best would be to employ them under temporary contracts, which are the same as fixed term contracts, okay? And that one would be more conducive to the type of job and circumstances of employment that you are talking about, rather than giving them contracts under independence of contracting. Like, they are not employees, but they are independent contractors coming to work for you. Certainly they are not consultants, or they may not be in that category of people who reasonably would have to be given a contract for employment. So this would be my views. You'll not be too safe from the SSNIT people if they really come and audit your books and your employment books. Yeah.
You're muted.
It is not me alone.
Yes. Thank you. And the course of mine is that different from Senyo's. So I want to pick your final views as panelists, 30 seconds each. I want to start from Jifa, then I'll pick that of Sam, and then we take that of Senyo. 30 seconds, your final thoughts on this business of contracting, its importance, why should HRs not take it for granted? HRs as representing the employer.
Okay.
Yes, Jifa,
So,
final 30 seconds.
Yes, I think that the HR and the employee should both know what category of employment they are in, whether it's a permanent one, whether it's a fixed one, what rights they are entitled, they are subject to, or the duties that are imposed on them by law. It will enable them to know, to structure the contract so that everybody's rights are protected, or nobody's rights are infringed. That's what I would say.
All right, thank you. Let's take the thoughts of Sam.
Yes, thank you, Jeff. I would say that employees are becoming very knowledgeable of their rights. There is, thanks to the internet and globalization, they can just Google and know what the issues are. So HR practitioners must be on top of their game and ensure that the contracts, address some of the issues we've discussed, so they don't run into any employment practice liabilities.
Thank you. Let's have the final one from Senyo.
So Jeff, thank you very much. What I just want to say is that when it comes to contracting, I mean, HR practitioners should look closely at the work, the job that is to be done, and issue the contract in accordance with that job. Because where you issue the wrong contract to the wrong kind of job, then you always run into problems. And we need to always use, consulting resources to help us get a standard template that is aligned with all the provisions of law, so that we do not get into trouble before we find help. Let's make sure that we get specialists to review and validate our templates, contract templates, before we use them, so that we are protected from the HR risk of lawsuits and conflicts. Yeah.
Yeah, thank you so much, our resource persons. And let me sincerely apologize to our listeners and viewers whose questions I was unable to read due to time constraints. It is not any sign of disrespect to you, but we sincerely want to appreciate you for your participation. We invite you to participate in our forthcoming labor law masterclass. It's happening from the 10th to the 14th of May. 1 week, Monday through Friday, 5:30 to 8:30 p.m. National Banking College is a center. It is also going to be available on Zoom, except it is not free. So you are paying for it. You can pick the number 0244 822 855. And that number again is 0244 822 855. Just send us a quick WhatsApp hello and indicate your name. We will furnish you with all details, including how to register. So in that one, we are not just limiting ourselves to contracting. We are looking at the Labor Act cover to cover. We are looking at the supporting legislation, the LIs 1822, 1833. We want to look at the other legislation of reference, the Workmen's Compensation Act, Factories, Offices, and Shops Act, the ADR Act. We want to look at the General Labor Framework, National Labor Commission, considerations for adjudication. So we have the immediate past chairman of the National Labor Commission who will be presenting at that program. You just contact us and then we will accordingly register you, whether you are coming in sponsored by organizations or as a private individual. Finally, we run the professional HR certification course. Those of you who are still not certified, our goal is one, our vision is one, to get as many professionals as certified as possible. People ask us, what's the difference between this one and the IHRMP? The same difference between CA Ghana, which is the local one, as the IHRMP, and ACCA, which is global. So we are the approved providers. And let me add, the only approved provider of the professional HR, of the HR Certification Institute. We represent them in Ghana. It's just a 6-month course, Saturday lectures only for those of you who prefer the in-person. Otherwise, you can also sign up for the online option, which runs on Sunday. And you have the liberty of switching in between every weekend, because the content that is taught in person on Saturday is the same content taught live on Sunday. And within 6 months, you are fully prepared to sit for the certification exam. On your passing, you are certified as a professional in human resource or as a senior professional in human resource. I want to take time out to specially thank our resource persons, Mr. Samuel Alote, for your time, Mr. Senyo Ajabin, Mrs. Jifa Vanderpoy, for the rich experiential knowledge you had shared with our listeners. And to you, our listeners, both on Zoom and on Facebook, we say a big thank you to you. And this was brought to you by the HR Certification Center. You can check us out at www.phrglobal.com. PHR stands for Professional Human Resources, phrglobal.com. Otherwise, you can connect with us on all social media platforms, HR Certification Center. Thank you all, and do enjoy your rather long weekend because Monday is a holiday. I wish you all well. Thank you so much.
Thank you.
Thank you, and bye.
Bye.